reputed professors, and my dear friends. I am highly privileged to host a workshop on IP management for prototypes and products organized by the Institution of Thermal Engineering. Kindness is always fashionable and welcome. Leaders become great not because of their power, but because of their ability to empower others. I am sure the knowledge gained from the seminar will be enriched to all. Optimism is the faith that leads to achievement. I am privileged to invite Dr. Muniappan, professor, to facilitate our chief guest. Positive thinking results in success. To become unique, the challenge is to fight against the hardest battle, which anyone can imagine until we reach our destination. I call upon Mr. Ramesh Kumar Kannan, founding partner of Quadiga, to take over. Sorry, sir. Now I would like to call upon Mr. Bharti Azad to give introduction to the
So good morning to all. So it takes me immense pleasure to invite our two experts for this wonderful program. First, I would like to introduce our first expert, Mr. Venkatesh Vishwanath, registered patent agent, registered trademark agent, and founding partner. Sir has completed his bachelor's degree in biotechnology in Shastra University and finished his master's degree in forest biotechnology at Oregon State University. So Sir is a registered Indian patent agent and Indian trademark agent. He adapted the crafting and prosecuting patent specifications in the agriculture, life sciences, mechanical and medical devices domains. So filing and prosecuting trademark applications and design applications also is forte. So he is currently an IP facilitator for startups and has provided services to almost 250 startups. Sir has presented and spoken in leading forums including those in Brazil, France and Canada. So I welcome you, sir. And then the next expert, Mr. Ramesh Kannan, registered patent agent, lawyer and founding partner. Ramesh Kannan finished his bachelor's law in Karnataka Law University and master's degree in physics from Manoranmaniam Sundaranath University. So he was mesmerized by the digital revolution occurring in India and taking the country by storm. Sir has also finished his master's physics in Alagappa University. He has also signed up with the construction majors admin department where he learned the ins and outs of industry and administration domain. So his specialization include complex licensing agreements, crafting and prosecuting patent specifications, due diligence and providing legal opinion on IP related aspects. His experience spans multiple domains and including automobiles, electrical, electronics, mechanical and IoT and other computer related inventions. He has spoken extensively in various forums and is passionate about startups and education institutions. Apart from being an IP facilitator for startups, he is a panel member of MHRD sponsored Institute Innovation Council in National Engineering College, Kovilpatti and Kapila Committee in Ramakrishna Engineering College, Coimbatore. And he has participated in many colleges and then giving so many lectures regarding this patent. So finally, to top it all, Ramesh is familiar with many of the administrative procedures and compliances, having worked from scratch to help with the establishment and day-to-day functioning of Hawaii-based software company's branch office in Chennai in his capacity as a branch manager. So he is also an ardent fan of history and the Tamil language and Weinstein by reading Tamil literature. So I welcome you, sir. I over to Mr. Venkatesh for Ramesh. So I will welcome Ramesh Kannan sir for the presentation.
Before jumping into the topic patents, I am here to make you understand what is patents. Before that, where it comes from. I will let you know later.
First, before going into there, we need to know what is intellectual property first. I am here to make you understand intellectual property first. I am here to make you understand the basics of intellectual property, what it is exactly. As like other subjects, whenever you are going to learn something new, you have to have a basic idea about what you are going to study. In any subject, you need to have a fundamentals strong. Then only you can able to build upon the subject to innovate something new. In any subject. Accordingly, I am here to make you understand what is intellectual property. It's very simple, it's a very straightforward. Intellectual property, there are two words combined together to make intellectual property. Intellectual, intellect, property. We all know what is property. We have a basic idea about what is property, whether it is tangible or intangible, anything, whatever may be, from the land, from house or two-wheeler or whatever may be, everything is called a property. So, again, you are combining the word property with intellect. Where it comes from? Why the word has kind together to form intellectual property? What is the connection between intellectual and property? Here is any property, any creation which comes out of human mind. Any creation which comes out of human mind. That is intellect. Human mind is nothing but intellect. Anything comes out of human intellect is called intellectual property. Then why the word property? Similar to property. Property means tangible or intangible asset owned by any person. That is property. It's a legal definition what I am saying. And even in colloquially, if you are having something in your hand, if you are owning something, whether it is a physical, tangible or intangible form, that is called property. Similarly, if you are creating something new, that creation is, you are the owner of that creation. In that case, you need to have something, some legal rights. Property is intellectual property. All those skills are creations of your mind. Such creations has to be protected in any one of the forms available. So what are all the type of rights available to protect all type of your creations? That is today's topic. One of such protection is patent. Apart from patents, what are all the other types available to protect is what I am going to let you know. So intellectual property, as I told you, there are different categories. Each and every category will be protected in different type of rights available. So basically, while talking about the intellectual property, since you are new, since you are students, we will make you understand. You have come up with some product, you have come up with some machine, or you have come up with some IoT based smart kits or smart device. Such creations have some technology behind it. Wherever a technology association in the creations, such technology has to be protected under patent. So technology can be anything, whether it is a product or a process. Even in a bio, you can come up with some bio compositions. Or similarly, if you are in a chemistry domain, if you can come up with some chemical compositions. Such compositions can also be protected. That composition is also a product. Such compositions can be manufactured in a certain methodologies. Such methodologies, method of manufacturing something. Such methods also can be protected under patent. So patents basically there to protect the technology behind what you have created. Is it clear? Patent is nothing but rights available to protect your creations if there is a technology behind your creations. This is the strongest form of intellectual property available, and not necessary to, we have to clearly explain what you have done in detailed manner to get a patent. And the second one is industrial design. This is a creation which has visual appearance. For example, we have this mic. This mic has its own visual appearance. This is also a mic. This is a different visual appearance. Similarly, whatever may be, wherever a product, each and every product will have its own visual appearances. So even in any product, even though there are so many products, even in your chairs, each and every chair has its own visual appearances. So you are making a product looks unique, even though the product is already available, that unique visual appearance of that product, if you have created that unique appearance of a product, such unique appearance of a product can be protected under industrial design. That will protect only the aestheticness of what you have created. Even in your creation, if you have intellectual property is associated with it. That's why I am saying it. The visual appearance of the product will be protected under industrial design. The technicality behind that creation will be protected under patent. Fine. The next step behind it, and it has its unique visual appearance, what we do? You are going to commercialize your product. In that situation, you need to have your unique name, a unique brand for selling your product in the market. In that case, if you want to prevent others from using your brand name, whatever the brands available in it nowadays, very well known brands, all the brands, such brands will be protected under trademark. Trademark, again, as I told you, intellectual property, trademark. A mark which is directly associated with a business. If you are going to do some business to sell something in the market, the trademark is not only associated with the product, also the trademark also can be associated with a service what you are going to provide. As we are doing our legal services in the name of Quadriga, Quadriga is our brand name. We are doing legal services in the name of Quadriga, so we have protected the name Quadriga and our trademarks. That by that way you can prevent others, your competitors, from using your brand name. Already you have protected your creation, the technicality behind your creation under patents, and the visual appearance under industrial design, and you are going to promote your product for commercialization in the market. There also you can avoid your competitors from using your brand name of your product by the way of protecting trademark. Trademark, trade is a business, mark is the word or a logo or a symbol, whatever you are going to use in association with your business will be protected under trademark. And the fourth one is the copyright. Copyright combines lots of different types of creations. As I told you already, somebody can have very good writing skills. Even if you are even a faculty or even a student, if you are writing a project report in your own way, the way how you are prepared your project report can also be protected as a literary work under a copyright. Similarly, if you have created a product, that product has been patented and a visual appearance of that product will be protected under industrial design. You are making a video for advertising your product in the market. Such video can be protected as a copyright. Similarly, a work manual you are preparing for your product can also be protected as a literary work under copyright. And accordingly, if you are making any songs or whatever literary writings, for example, work manual or user manual, such kind of things associated with the product can be protected as a copyright. Any literary work, artistic work, videography, cinematography, everything will be protected under copyright. Apart from that, photography and artistic, if you are a drawing, if you are a very good artist, you can draw a very good drawing. Such drawings can be protected under copyright. If you are a very good photographer, if you are visiting lots of places and you are taking lots of photographies, such photographies can be protected under copyright. You are shooting something, if you are a very good director, if you are interested in cinematography, if you are taking a small short films and all, and such short films can be protected under copyright. So, whatever may be the type of creations, depending on the type of creations, there exists an intellectual property right. Accordingly, you need to identify which intellectual property suits your creation, and then you need to approach a proper person to protect your intellectual property, and that way you can prevent your competitors from copying your creations. That is a core idea behind the intellectual property rights. So after registration, it will gives you a monopoly rights over the creation what you have done. So that particular monopoly rights makes it's a kind of, if it is a product, that product may be available. You will have only one vehicle. By that way, you can understand property rights. You will take it forward to make you understand in detail about what is meters. Thank you. Thanks for listening.
Thank you, Ramesh, and good morning, all of you. So, when we started the session, the person who spoke first, mentioned that leaders are defined by how they empower others. So, I want to throw open a question to all of you. Which is the single most defining factor that empowers a company these days? Any answers? There's no right or wrong answer, just throw out answers. No? Design, okay. Data. Any other answers? Let's make it interactive, come on. So both the answers that came out till now are more or less right. Design and research and development. So basically, intellectual property is the single most defining factor that empowers companies these days. We have moved from an era where tangible assets constituted most of a company's assets to an era where intangible assets are constituting most of a company's assets. So intangible assets are assets, that can't be, visually seen. Earlier, if you looked at a company's balance sheet, it would be land, it would be capital, it would be machinery, it would be, anything that could be seen, that could be easily valued. These used to constitute, the major portions of a company's balance sheet. Nowadays, things are literally reversed. It is like human resources, intellectual property, and all other intangible assets are what you will see on a company's balance sheet. So the topic of today's session, IP management for products and prototypes. I was told by Dr. Satish that they are encouraging you in the third year and fourth year to actually to come up with a startup rather than do a project, which is very good. All of you are fortunate to be living in an era where the government of India is promoting startups and educational institutions are also slowly changing their policies to ensure that outdated policies are being done away with and students are being encouraged to become entrepreneurs. But when you come up with a product or a prototype, given that intellectual property is the single most defining factor that empowers companies these days, we live in a cutthroat copying environment. Do you agree or not? When you go out to a market, how many copycat products have you seen? So, if you want to avoid such copying, or if you want to ensure that you retain the flexibility to take action against those who copy, whatever it could be, who copy your design, who copy your technology, who copy your brand name, the first thing you have to do is make sure you learn the basics of intellectual property, because that is what will help you identify whether the technology or the product or the brand name or the design that you have is registrable or not. That is the fundamental principle that you need to learn these days as an entrepreneur or a businessman. If you have any idea of starting up a business, identify your IP. The next step is to identify the applicable type of protection related to that IP, which is what Ramesh explained now. So if you have identified a particular type of technology that seems to be new, then you have to protect it under patent. If you have a brand name that you think is fanciful, protect it under trademarks. If you have come up with a new type of design, protect it under design. But remember that one type of product need not always be associated with one type of IP. That is why we always call intellectual property as a bundle of IP rights, bundle of rights. So, if you look at an electric bike is a brilliant example, or an electric car. It's a wonderful example of IP being a bundle of rights. It could have new technologies in it, which are patent protected. It will have a brand name on it, or a company name on it, which would be registered by trademark through trademark protection. The design of the bike or the car and design of individual components inside the bike or the car would be registered through design protection. And because it's an electric vehicle, it will have some propelling algorithms or software behind it, and these could be protected through copyright. So remember that it is not always a one-to-one association. The two things that you need to remember: identifying your IP and identifying all the types of protection that are applicable to the IP that you have identified. This is the first step towards IP management for products and prototypes. Now the second step is I will be dealing in a bit more depth with regards to technologies, because that is the most predominant form of IP. All of you are engineering students, and all of you will be coming up with quite a few technologies. Dr. Satish informed me that there are a lot of you who come up with machine learning algorithms and artificial intelligence related products, apart from herbal compositions. So all of these are new products, new technologies. Some of these are new technologies, some of these are new products. And the most predominant type of IP that is applicable to these is patent protection. Before I go further, do any of you have any sort of exposure to patents? No. Okay. What do you think is a patent? Louder.
All rights will be taken over by the owner who has invented.
All rights will be taken over by the owner who has invented. Okay. But what is that right granted for?
Benefits and the profits.
Huh?
Benefits and the profits. That we
Okay. But what is a patent basically granted for?
Without copying,
Huh?
without copying the others.
Okay. A patent is basically granted for a technology or an invention or an innovation. Your answers were right. So all rights are taken over by the owner. Yes, of course. So if the inventor is different from the applicant, all the rights belong to the applicant. And a patent is a legitimate right, as the other answer said. It provides you with a monopoly to prevent others from copying your technology or your product. So whenever you talk about a patent, there are 5 things to keep in mind. A patent is a monopoly right, as Ramesh already mentioned. It's an exclusive right. And as we have already said, it is a negative right. It prevents you from, it empowers you from preventing others from copying your technology or product. So second thing, whenever we talk about a right, is the term of protection. Who grants it? It is granted by the government of any country. Patents or any other form of intellectual property rights are territorial in nature. Just like any other property. Most of you at least may have driving licenses issued by the government of India. Can you use that driving license in any other country? Same thing with intellectual property. An intellectual property issued by the government of India can only be enforced within the government of India, within the territory of India. It is valid only within the territory of India. Likewise, a patent issued by the US Patent and Trademark Office is valid only within the US. So it is granted by the government of any country. term of protection. It does not empower you for an indefinite period of time. It empowers you for a period of 20 years from the date of filing, which is a long period. But what does the government expect you to do in return for that right that you get? It expects you to completely disclose your invention. And that is where a lot of inventors have problems. Their problem is that if we completely disclose our invention, it makes easier for other people to copy our invention. Well, yes, right. I won't disagree, because I was the one who said sometime back that we live in a copycat environment. But unfortunately, that is how the patent system works. Because the fundamental principle of patenting is to ensure that whatever you have come up with is in the public domain, so that not others can copy your product, but so that others can study whatever you have done and improve upon whatever you have done. And a side effect of that is others will copy your products. That cannot be prevented, but it is far better than keeping your invention as a trade secret and someone else obtaining a patent over the same invention. That becomes an even more of a hassle for you. And like I said, patents are only awarded for technical inventions and innovations. It could be anything that is technical. Usually, when we come up with the word patent, we think about only breakthrough inventions or revolutionary inventions. You know, something like when Sony came up with the Walkman at that time, that was revolutionary. When Apple came up with the iPhone, that was revolutionary. So we only think about those sorts of things as patent eligible subject matter, which is not right. Across the world, 95% of the patents that are filed for or even granted are only for incremental inventions and innovations. Anything that is usually or breakthrough inventions. So, whenever you think about a project, an idea for a project, use a problem solution approach. First, find out a problem. Study whatever has been done earlier. Find out a problem in whatever has been done earlier. And so that the public can study what you have done, and if they want to improve upon whatever you have done, they can do it. So always use a problem solution approach. Always do some background work before you start on a project. Just study at least one solution that has been done earlier and identify problems in that solution that has been done earlier. In legal terms, we call this white space analysis. All of you might have read the term white space somewhere. So it is basically identifying gaps and try to fill in gaps. That is why there are a lot of products that solve the same problem out there. All of them solve it in different ways, and all of them have different technical advantages. Or else the supermarkets or hypermarkets. Does anyone know who the gentleman is? No one? Okay. He is George Fernandez. Heard of the name? So he was a Minister of Industries during the 1970s. And later also, I guess he was a minister. So when George Fernandez was the Minister of Industries, he forced Coca-Cola to disclose its formulation and to transfer its trade secret to Indian companies so that Indian companies could make the same formulation. But what did Coca-Cola do? It instead opted to exit the Indian market, and it later returned only after the Indian economy liberalized in the early 90s when Manmohan Singh was the Minister for Finance. That really shows the value that Coca-Cola had towards its trade secret. But not all of us can afford to have the same value towards each of our IP. If you think something is really, really valuable, and it is not easily copyable by others, then you may opt to protect it as a trade secret. But remember that investing in trade secret protection will be quite expensive. And if the trade secret somehow leaks into the public domain, it is quite difficult to get back that trade secret. Only as long as the trade secret is not leaked, it remains as a trade secret, unlike a patent, where once you get a patent, you enjoy that right for the full duration of 20 years. Here, only as long as you maintain it as a trade secret, it remains as a trade secret. So you have to do whatever it takes to ensure that it remains as a trade secret. That may be possible if you are a small startup, if you are the only person managing the startup. But as you begin to grow and grow, it becomes difficult. Especially if one or more of your other employees need to have access to the trade secret partially or fully. It's a self-explanatory term. What is reverse engineering? Have any of you purchased products from the market and then broken it down to see what it has?
Yes, sir.
That is reverse engineering. So if you can start with a product and then come up with how the product has been come up, and then find out how the product has been come up with, that is reverse engineering. Trade secrets can be protected for an indefinite period of time. And in India, there is no specific protection for trade secrets. Trade secrets are only governed by the Contracts Act. So you need to have strong clauses in place in contracts. Like I said, patented inventions can be breakthrough inventions or they can be incremental inventions. And anything in between. It's a huge spectrum out there. So, shopping carts can also be protected through patents. If you have built in some new technology in the shopping cart, a smart shopping cart. Shopping cart is something which we see everywhere and we don't usually associate it with patents. But if you have built a shopping cart with a new technology, then that can also be protected through patent technology. Due to project. So this is the Bajaj Pulsar where DTSI technology was protected. And that gave Bajaj a big push in the market when it was down at that time. It helped Bajaj regain its market position. So patents provide companies with a really, really competitive edge these days. Now that you know about what is a patent, why should I patent? One of the reasons I already mentioned before, but there are a few other reasons as well with regards to why you should patent. Patents are for the general public good. As students and faculty as well, especially in the academia, there is a misconception that only scientific journals are for the promotion of research and development, whereas patents are for commercialization. No, that is not right. Patents are also for the promotion of research and development. In fact, unlike scientific journals, patents are where you can find a lot of unique literature. So when faculty and students, as faculty, when you go to approach a faculty for a project, they will generally ask you to do a background study, and you generally study only non-patent literature. Next time, try to see patent literature as well. Just go to Google Patents. You will be surprised by how strikingly different the results are when compared with non-patent literature and patent literature. So patents are for the promotion of research and development, and this is explicitly written into Indian patent law as well. You can generate revenue through assignment or licensing. So what is the difference between assignment and licensing? Does anyone know? Okay, forget assignment and licensing. Let's say you own a house. What are the two different ways in which you can generate income from the house.
Rent.
Rent it or sell it. Correct. That is exactly what assignment and licensing means. In assignment, you sell it off to someone for a lump sum payment. So the person who buys it becomes the new owner of your IP, whereas you receive a payment. In licensing, you retain the ownership over your IP. You just tell a third party, I am the owner of this IP, but for some reason I am not able to commercialize this IP. So I will give you the commercialization rights. You manufacture it, and we will have an agreement between us in regards to how the profits can be shared. You can provide the license to only one party, which will the third part is especially relevant to students and faculty. The inventor gets recognition among the peers. They try to publish it first and then they go for patenting. And somehow the patent office during lunch finds out that it has been published earlier, and the earlier publication is cited in the examination report. It becomes very, very difficult to overcome the objection. Does anyone know how Toyota started out? Toyota is a modern day automobile giant, all of us know that. But what was the fundamental basis on which Toyota was started out? Does anyone know? It is a very good example of how patents can generate revenue through assignment, and you can spin off a business from that revenue. Toyota was started out as a spinning and weaving company, whether you believe it or not. And it was established in 1918. So the owners patented an automatic loom in the year 1924, 6 years later. After they founded, they invented an automatic loom and they patented it. And based on that patent, they established a separate company, Toyota Automatic Loom Works, in the year 1926. This patent was sold for 100,000 pounds. When in the early 1920s, 1930s, automobiles of the manufacturers in the world. This is a classic case of how a patent can help you generate revenue through assignment, and you can completely diversify your business from the revenue that has been generated. This goes back to what I spoke in the beginning about intangible assets constituting a major portion of a company's assets. So here, if you look at this is the components of S&P 500 market value. S&P 500 is a indicator that is used, for the top 500 companies. I think it is in the US. You can see how, there has been a revolutionary shift. In 1975, only 17% was intangible assets, and 83% was tangible assets. And slowly, the white bar has become the red bar, or rather, the olive bar, and the 70% has come to the gray area. This is how it has shifted, and I'm sure, we will be reaching a stage where, tangible assets literally become negligible, 5% or even less. That is where the world is headed. So it is about intangibles all the way. Intangibles are what define your company and empower your company. So make sure, at this stage itself, you know what. One of the core around which venture capital decisions are made these days is intellectual property protection. I was talking to Dr. Satish before, starting the seminar, and he informed me that they had organized a session where they called in investors. So investors these days, a lot of them mandate that you have your intellectual property protected before you even approach them. And some people have gone one step further. They want a granted patent in place before you approach them. That is how they are advancing. Earlier, you could just approach any investor with a technology or a prototype or a product, and they would be happy to help you if they are really impressed. But that's no longer the case. They have also changed according to market because now in today's market scenario after the pandemic, they want to ensure that every paisa that they invest, they get a return on it. They have become very, very strict in their assessments and criteria, and if you don't have your IP protected, they will literally, turn you back. They will tell you first, go and file it and then come to us, we can talk whatever we want to talk. That is how the market is changing. So, this is how India is becoming nowadays, but this is how developed countries have been for quite a while now. A study of 204 biotechnology startups in Canada showed that, if the company had more patent applications or more granted patents, the company is likely to have access to significantly higher venture capital. And this is how the Indian market is also becoming right now. So I talked about licensing and assignment already. Licensing is where you retain the ownership rights and you give the commercialization rights to someone else. Assignment is where you completely sell it off. You say that, okay, I've invented it, my job is only to invent it, I don't know how to commercialize it, I have no business commercializing it, so I will sell it off, I will move on to my next invention. There are people out there who do that. They only know how to invent. They will invent, they will sell it off, they will move on to their next invention. Can be done. But make sure that you know what you are doing. Whatever it is. There are n number of strategies out there, but you have to have a defined strategy in place. Once you have a defined strategy, stage where there is no turning back. No chooses to take legal action against you, it becomes a very big hassle for you, and at that time you have to all your works, on the back burner, and you have to concentrate only on the legal, which will become a very big hassle for you. So give priority to IP right from the beginning. It will help you in the long run. In 2009 itself, global royalty revenues from licensing exceeded $180 billion. You have a lot of companies who are masters in licensing, like Disney, for example, like IBM. These companies have mastered, the licensing of their brand names and technologies, and they develop and they generate plenty of revenue through it. So, licensing is one model, which can help you generate a lot of revenue. You don't need to commercialize your invention on your own. You can always take the assistance of other established people in the market, to help commercialize your invention. Provided, this is a very important point, you have strong agreements in place between them. If the agreement people have this are not multi-purpose templates. They have to be customized according to your need and use. Unless you customize that according to your need and use, that template has little value, which you will realize only later if some clause of the contract has been breached and you realize that you are unable to take legal action because that clause is weak. So make sure that either you study the agreement carefully or you take the opinion of a legal practitioner. In fact, these days even legal practitioners use templates. So make sure that you approach a legal practitioner who knows what he is doing, and make sure that you have a strong legal agreement in place. Assignment Examples of other types of assignments include your employment agreements. So, all of you are students. Once you graduate, you will either have your own startup or you will be joining companies. When you join a company, your company will give you what is known as an offer letter, an employment agreement, an employment contract, whatever it is called. And these days, whether your employment agreement has other clauses or not, it will have a big section related to intellectual property and non-disclosure. All your other clauses, you'll have to search for them somewhere in the agreement, but this clause will be predominantly visible on the employment agreement. It will say that any intellectual property that you generate as part of your employment duties will belong to the company. The company is the applicant of that IP. You will need to have similar agreements in place if you start up and you decide to recruit employees later on. Make sure that all these procedures are properly followed so that you face no hazards later. All licensing and assignment agreements or contracts must be recorded in writing, which is what I said. They have to be properly in place as legal documentation, which can be referred to later, and they have to have value and strength. Patents as collateral. Patents can also be used as collateral. It is not just your house or gold or other types of tangible property that can be used as collateral. Intangible properties such as patents can also be used as collateral to generate revenue through loans. So the second logo on the right, Silicon Valley Bank, has been in the news of late. Has anyone read it? Bankruptcy, correct. It was one of the pioneers that actually established the process of using patents as collateral to give out loans to startups for their development. But due to mismanagement practices or whatever it could be, the bank has now gone off. It is at the stage of not functioning, and it has to be taken over. If you don't have an application number, if you have not protected but the truth is, you can obtain patent protection for products and processes. Both of them are equally eligible for patent protection. But what are the criteria that they have to fulfill? They have to be novel, they have to possess an inventive step, and they have to be industrially applicable. They should not fall under Section 3 and Section 4 of the Patents Act. Each of these criteria will be dealt with in the next slides. First slide, the first criteria is novelty, which I think is self-explanatory. Novelty is a common English word. What is its meaning? What is novel? Something new, exactly. That is precisely what it means in patent terms as well. Your invention has to be new. Now, when does it have to be new? It has to be new at the time of filing. Your filing date is what matters with regards to patents and determination of novelty and inventorship. And how does the patent office determine whether it is new? The patent office determines whether it is new by comparing it with prior art. What do I mean by prior art? By prior art, I mean prior publication, prior use, or prior knowledge. And each of these three is not necessarily restricted to the territory of India. They could be in India or they could be elsewhere in the world. Which is why I said the next time you start a project, try doing a patent search on Google Patents. That will give you an extraordinary amount of literature which you would not have gone through non-patent literature search. And it will give you literature in China, it will give you literature from Korea, because these are the economies where, these are the invention hotspots. These are the R&D hotspots. This is where, a lot of inventions are happening. And when you do a non-patent literature search, what you will generally find is publications from Indian inventors, publications from US inventors, publications from EU inventors. That is what you will generally get. You will not generally get, Chinese, publications of Chinese people or publications of Korean scientists. But that is where a lot of, R&D is happening, especially related to IoT, related to semiconductors, electric vehicles, electronics, you name it. China, Korea, Japan, these are hotspots. And the patent office does a global search to determine whether your invention is new at the time of filing. And once the patent office comes up with a prior document, how does it determine whether that document is relevant to your invention? It does a one-on-one comparison. It will split up your invention into features. Your invention may have 5 features, A, B, C, D, and E. And it will split up the document that it has found into features. And it will be a literal comparison to determine whether all the features that are there in your invention are there in the document that has been found as well. So it is one document versus one invention. A comparison is done to see whether your invention has novelty or not. This is a fairly straightforward criteria. Very, very rarely do inventions, get refused under novelty, unless you have literally copied an invention, or you have published your invention in a scientific journal before filing a patent application, and the patent office comes up with your own publication. Otherwise, you can generally come up with some distinguishing factor to ensure that your invention is novel over whatever is already available. But it is the inventor step criteria that really matters. Indian Patent Office follows a system of absolute novelty, which means that, like I said, it does a worldwide search. And this is not restricted to just India. Many patent offices across the world do a worldwide search. So that is how the international standard is. Even though the patent is restricted to the territory of that particular country, while doing the search, they do a worldwide search. And remember that even something like a PhD defense, or project presentation may also be considered to be a public disclosure. It's a case-by-case basis, it varies. So make sure that when you have the necessity to disclose your invention to a third party whom you are not confident about, whom you think will not retain the confidentiality of the invention, make sure that you try, as far as possible, you disclose as little as possible, or if it has to be entirely disclosed, try signing non-disclosure agreements with them, which will help protect the confidentiality of your invention. Now, just a very small, case law. It's a relatively simple case law that you will be able to understand to, determine how novelty is, estimated or come up with by the patent office. Two giants fought against each other, Tata Chemicals and Hindustan Unilever Limited. All of you know that, these two are very well known names in the FMCG sector, fast moving consumer goods segment. And that is where I believe a lot of you are working on when you, come up with, WhatsApp, YouTube. Basically, if you look here, on the left hand side is HUL's product. So, there is a hollow tubular passage in the center. Country. There are just a few case laws which help define this person. In India especially, Justice Prabha Sridevan in Sankalp vs. Roche defined this person as one who is not ignorant of the field's basics, nor is he ignorant of the activities in the particular field, and he is also not in the domain who can read and understand what you have come up with, and who can read the cited documents and try to ascertain whether the cited can be used to come up with your invention. It's a lot more complex than this. Just assume that you have come up with the compositions. Assume that you have come up with a composition which comprises a resin, a soap, and a hardener. Two documents have been cited by the patent office. The first document, discloses the same resin and soap that you use, but it discloses a different hardener. The second document cites a different resin and soap, but it discloses the same hardener that you use. And assuming the technical effects provided by all three documents are the same, your composition does not confer your invention with any unique technical advantage over these two compositions, the patent office will say that these two documents can be combined together and your invention can be aligned. Which is why I told you in the beginning to follow a problem solution approach. If you had followed a problem solution approach, these kinds of problems may not arise because you would have thought about the problems right at the beginning. And your invention overcomes that problems, so it will have some sort of technical advantage when compared to at least one-sided document. Whereas if you don't do your background research before you come up with an invention, later on these sorts of problems may arise. Sometimes they may be overcome, sometimes they cannot be overcome. The most simplest criteria which generally all inventions fulfill is your invention should be capable of being made or used in an industry, which is what all of you come up with. Whether it is artificial intelligence, machine learning, electronics, automobiles, herbal compositions, all of them have an end use in one particular industry at least. So this is generally, I have not seen any invention being refused under lack of industrial applicability. Some special provisions related to the Indian Patents Act. Protection of biological diversity. India is a land India instituted what is known as TKDL. It is an acronym for Traditional Knowledge Digital Library. It is a great initiative by the Government of India. Unfortunately, not many people know about it. Like many other Government of India initiatives, it is just lying there. But it's a wonderful initiative from Government of India. It was formed between collaboration of CSIR and Ayush. Does anyone know what Ayush stands for? Traditional Indian systems of medicine, what are they? That is exactly how that acronym was coined.
Ayurveda, Yoga.
Ayurveda, Yoga, Unani, Siddha, or Homeopathy. So you have an example where a European patent was granted for use of neem as an insecticide. This is what our farmers still do nowadays. A lot of them are small-scale farmers. A patent was granted by the EPO and India had to fight it. A USPTO patent which I talked about on wood healing properties of turmeric. So in order to fight these cases, nowadays the Indian government relies on literature which is available in Ayush. The problem is we have a lot of traditional literature which is scattered across in a lot of different languages. Which makes it these have made it to the headlines of leading newspapers. India foils UK firms bid to patent use of turmeric, pine bark and tea for treating hair loss. Filed a patent application in India. As well. It is your duty to disclose the information of the correspondent office also later go against you if someone opposes of your patent. Now, let's say you have obtained a patent. Like I told you, one of the very fundamental principle of patent law. A lot of people think that the fundamental principle of patent law is just enjoying monopoly, which is wrong. Enjoying monopoly is only one part of patent law. The second part of patent law is to ensure that society is benefited as a whole through the commercialization of the patented product or process or technology, whatever it may be. Which is why has compulsory licensing mechanisms in place of its own. You can ask the patent office to force the third party to compulsorily give you a license so that you can commercialize the product or process or technology. This is what is known as compulsory license. These provisions are especially applicable in the fields of medicine and pharmaceuticals. It is a matter of life or death. If a company gets a patent for a medicine and it either does not manufacture the medicine on its own, it does not give a license to third parties, and it just sits back on the patent and tries to enjoy monopoly, it is a matter of life or death. Which is why we have compulsory licensing provisions in place. There are three criteria for the issuance of compulsory licenses. Reasonable requirements of the public are not met, not available at a reasonably affordable price, and not being worked in the territory of India. On any of these grounds or on a combination of these grounds, you can approach the patent office for a compulsory license. The next provision is related to the commercialization of your invention. It is known as statement of working. Every year, you have to provide to the patent office the details of whether you have commercialized your invention or not, how much you have commercialized it, and if you have not commercialized it, why you have not commercialized it, what steps you are taking to commercialize it. So, the patent office will can also monitor whether your patents are being commercialized or not. And third parties can also monitor whether your patents are being commercialized or not. When I talked about patentability criteria, I talked about Section 3 and Section 4 of the Patents Act. Indian Patents Act contains an explicit list of inventions that are not patentable. And these are defined under Section 3 and Section 4 of the Patent Act. So even if your invention satisfies the novelty, inventive step and industrial applicability criteria, if it falls under Section 3 or Section 4 of the Patents Act, your invention will not be granted a patent. The first criteria is inventions that are frivolous or obviously contrary to well-established natural laws. So all of us know that when an apple falls down from a tree, it falls down. If you are going to say that I have come up with a theory wherein the apple goes up, that's contrary to the theory of gravity. Patent office will not grant you a patent. It's contrary to well-established natural laws. Or if you have come up with an invention that is contrary to public order or morality, let's say you have come up with an invention where counterfeited money can be printed at home. All of us can become rich, but it's contrary to public order or morality, so it will not be granted a patent. The mere discovery of a scientific principle or the formulation of an abstract theory. Engineering is based on a lot of scientific principles, and if you are saying that I have just invented a principle or I have discovered a principle, that will not be granted a patent. A new form of a known substance a new use of a known substance, a new property of a known substance, or a mere use of a known process. All of these are discoveries. That is why they are not granted patents. A new form, a new use, a new property, or a mere use. A new form is patentable if there is an improvement in the efficiency. But the rest are not patentable. A new use, a new property, or a mere use. A mere admixture, meaning you come up with a composition in which there are 3 components, and each of these components just combine together in an additive manner. That cannot be patented. A mere arrangement, rearrangement, or combination of known components cannot be patented. Now, this section is pretty important. Agriculture or horticultural methods and methods for treatment cannot be patented. So, if you come up with a new method for treatment of cancer that cannot be granted a patent, that will be used for the public good. But if you come up with a medical device for the treatment of cancer, that can be patented, but the underlying methodology cannot be patented. Likewise, if you come up with a device for spraying of pesticides or fertilizers, that can be patented. But if you are going to come up with a new method of sowing crops, that cannot be patented. It will be used for the public good. Plants and animals and essential processes for their propagation cannot be patented. Mathematical or business methods or a computer program per se or algorithms cannot be patented. The term per se refers to on its own. Computer programs per se means computer programs on their own cannot be patented because they are only eligible for copyright protection. But if you can combine a computer program with some sort of hardware, it could be a novel hardware, it could be a non-novel hardware, and if you package your computer program as a product with hardware, then that becomes eligible for patent protection. Topography of integrated circuits, there is a separate type of IP for that. Traditional knowledge, for reasons mentioned earlier, cannot be patented. And any invention that falls within the scope of section 20 of the Atomic Energy Act for defense purposes cannot be patented. So, now that I have told you about section 3 and section 4, assuming each of these inventions satisfies the novelty, inventive step and industrial applicability criteria, let's just see whether they fall under section 3 and section 4 of the Patents Act. What about a method for treatment of cancer?
Not be patented.
Ready to cook millet, mixed from pearl millet.
Process kuda
Not patented.
Patented.
Huh?
Patent.
This is a patentable subject matter. Polyurethane foam coated with silver nano.
Patent.
Patentable. A microorganism existing in nature.
Not
Not patentable. Automated transmission system for an automobile.
patent. Patentable.
Patentable. A mobile phone with a stethoscope.
Patent.
An improved cricket ball throwing machine.
Patent.
Patentable. Law of gravity.
Not
patentable. Brilliant. All of you are now subject matter experts. The patenting process. Quite a tedious and arduous process. But broadly it involves 4 steps. Filing an application, generation of an examination report, responding to the examination report, and finally hearing. But not all applications have to compulsorily go through these 4 steps. The maximum number of steps is 4, but it could be granted earlier as well. There are 2 types of applications that can be filed. One is an application accompanied by a provisional specification. One is an application accompanied by a complete specification. If you have an idea Your ideation is at an advanced stage and you just need more time to build your prototype and test the idea. But your ideas of the form that it can be written on paper. Then you can file a provisional patent specification, provided that within 12 months you are ready to file your complete patent specification. Or else your provisional patent specification will lapse. Or else if everything is ready, you can directly go for a complete patent specification. The patent specification is known as the document where you completely put your invention in writing for the patent office to study and understand your invention. It's a techno-legal patent document. After that, after 18 months from the date of your first filing, the details of your patent application fall into the public domain. This is why a lot of people are scared that their invention will be copied, because mandatorily after 18 months, the details of your application will fall in the public domain. It will be published in the Patents Journal, which is published by the Patent Office. After that, anyone can access the details of your invention. Between the date of publication and the date of grant, anyone can oppose your patent application. Within 4 years from the date of filing application, thereafter it will fall into the examination queue. It will be taken up for action, will proceed to grant. If all the objections have not been complied with, a hearing will be called for, and thereafter the patent office will either after grant, within 1 year from the date of grant, your patent application can be opposed on the basis of post-grant opposition procedure. So at no stage your application can be opposed by competitors. That is how the Indian Patents Act is built to ensure even if you have come thereafter you have to pay renewal fees to keep your granted patent in force. Just one slide devoted to international patents. When clients come to us, the first question that a lot of people ask us is there an international patent? You know, is there one patent that will give me protection in 190, 200? In foreign countries, once you file a patent application in India, thereafter you will get another 1.5 years from the date of filing of the PCT application to decide the countries where you want to enter and to file corresponding patent applications in those countries. So from the date of first filing, you get almost 2.5 years to decide where you want to file. This will give you time to judge your market potential, to judge the commercial potential of your product or process or technology, and to ultimately file